This scene was your dream. A wonderful marriage, children, and companionship with the same person forever. Now you are facing one of life's most difficult and emotionally charged situations: divorce. How can you best manage the challenge of breaking apart the life you've had together and beginning separate journeys? Especially when feelings of hurt, anger, fear, and loss threaten to overtake you. Most of all, you're concerned about your children and want to assure them that everything will be okay.
This is enough.
You've heard the adversarial divorce stories of others and seen the damage.
We just gotta figure this out. You don't want to do it. Okay. Well, what are we gonna do?
You'd like to believe there is some way to achieve a better outcome. There is. It's a method called the collaborative way to divorce.
I'll agree to it. That sets the tone and how we're going to.
The collaborative method of divorce offers a dignified, effective, and strategic solution to a difficult and emotionally charged situation. When you choose this method, you are committing to resolve all of your issues through a collaborative process rather than through an adversarial battle.
Well, the collaborative law is different in that it's a method for a couple in a divorce situation to get an agreement with regard to their divorce by working with two lawyers, all in the context of not going to court. And it's not just a context of not going to court, there's a commitment on the part of the lawyers that they will not go to court.
Collaborative law is primarily a process in which we use four-way meetings. The clients and their lawyers get together through a series of four-way meetings and use a process called interest-based resolution to resolve their issues. Now, at the beginning of that, they sign this very important document called a participation agreement, which defines the way that they're going to commit to the process, the way that they'll share information, and helps them define how these four-way meetings will work.
There are many advantages to using the collaborative method. It preserves the family relationship and co-parenting, and especially benefits the children. It's generally less costly and quicker than going to court, without the financial and emotional scars that happen in battle. The emphasis is on cooperation over confrontation and resolution over revenge. You will communicate directly, avoiding acrimony and misunderstandings that can result from traditional negotiation and litigation methods. The process can prove to be a healing experience for you as a couple, while you forge a new and healthy relationship. The skills you develop will give you confidence that you will be able to resolve future issues, and the outcomes are controlled by you and your spouse and not by outside parties.
Many times people have a hard time grasping the concept of collaborative law, and not only the concept, but what happens. And so the video is going to set the tone of that, of how it works, and then take us through the process.
What we're hoping to do here is to explain it to them and help them see how it works from the very first four-way meeting all the way to the final signing of the papers, and including meeting with team members so people can get a real picture and a real understanding of each stage of the process.
Now that you and your spouse have agreed to the collaborative process and have each selected collaborative attorneys, the first step is to meet separately with your attorneys to help you prepare for your first four-way meeting.
One of the first things I want to talk about.
During this meeting with your attorney, you will go over the participation agreement that commits everyone to the collaborative process. Your attorney will also help you prepare for your first four-way meeting. You will hear a summary of what to expect at the meeting and receive helpful information, including a review of the ground rules and a written agenda for the meeting. You will find out what you will need to do before the meeting, like gathering information about your assets, income, and expenses, as well as information about the needs of your children. Most importantly, you will need to spend some time considering your own interests, needs, and goals. Success in the collaborative process depends a great deal on your ability to identify your big picture goals and interests so that you can make sure that time is spent on things that matter the most to your future. Throughout the process, your attorney will help you explore the options available for addressing these goals.
I just want to make sure that
This meeting is also an important time to ask any questions you may have and share your concerns.
Preparation for the first four-way is very important. And one of the things that's important is to prepare the client for what to expect. Another thing is to contact the other lawyer and make sure we're on the same page. And one of the things that's very, very important that's often tended to be neglected is preparing a good agenda of the first meeting.
We spend a lot of time with clients helping them prepare, helping them look at their goals, helping them prepare themselves emotionally, because if they're the ones that are going to achieve the results, they're the ones that really need to be able to focus on how to do that. The attorneys primarily act as managers of the process, so we work with them to try to help them understand what's going to go on in a four-way meeting, but the more time we spend preparing them, the more likely they are to achieve success.
The first four-way meeting will most likely take place in the conference room or offices of one of your attorneys.
We're glad we could all make it here today. This is our first meeting.
For many people, this first meeting may be a tense and emotional, but necessary step. The attorneys will work with you and your spouse to create an environment that helps you use this time effectively.
Signing an agreement that sort of sets the tone.
At this meeting, each attorney will begin to establish a relationship with their client's spouse as well, so that all four of you will begin to build rapport for future negotiations and meetings.
Suggested ways to
The first four-way meeting is about 2 hours in length and will set the tone for the entire process. A significant portion of the meeting will be spent reviewing the participation agreement and establishing the ground rules that will guide the behavior of the participants.
Much of the success of collaborative practice is based on communication. Part of what's happened in a marriage is communication is broken down, and we need to try to restore as much communication as we can to help them achieve the results in the process and to help them communicate better afterwards. The ground rules are just ways that they can communicate better within the four-way meetings and sometimes outside of the meetings so that they can have more effective communication.
use I statements talking to the couple. Don't say you did this. Say I feel that, or so that it helps the communication. It's designed that way. Another one is to avoid positions. Think in terms of interests. Another one that I like is if you're complaining about something, in making the complaint, also make a possible way it could be changed.
During this initial four-way, you and your spouse will share and exchange the information that the two of you have agreed to bring, such as bank statements, mortgage documents, pay stubs, etc. And you will start to identify your common and individual goals and interests, setting priorities with the help and support of your attorneys.
Many times, if we can get both parties to talk about their goals and they come up with fairly mutual goals, we can find ways to get the parties to meet their goals. And that's often we call it a win-win situation. Both parties have won because they've got their goal.
What I ask clients to think about is what's going to matter to you 20 years from now when you look back. What are the things you're going to care about? And usually they'll say things like, I want my children to be healthy, I want to be able to get through this emotionally, I want to get through it financially. Sometimes they'll say, I want to make sure my spouse gets through it right. I want to make sure we end this with some dignity. Often when you get clients to focus on goals, you'll find that they have shared goals and common goals. They probably have more in common than they do that they differ about. The more we get them to think about big picture goals, the more we're able to focus on what matters most, and the more we're able to find common ground that makes the compromises easier to reach.
Finally, future meeting times and places and the agendas of these meetings will be planned. You'll decide what homework each of you will have to accomplish between these meetings. This may include scheduling appointments with specialists or new team members that you've identified.
The collaborative process is a team process in that we bring in other people to deal with other aspects of the divorce. Lawyers can help you deal with the legal part of the divorce, but the emotional part, the parenting part, and the financial part need other experts. So we work with child specialists to help you with your children, work with financial specialists to help you focus on the financial issues, and work with coaches and mental health professionals to help you deal with some of the communication or emotional issues that occur in a divorce.
Many times people say, well, I don't need all those team members, it's going to cost so much more. And one of the things that they need to look at is that often those specialists that work on hourly rates that are lower than the lawyers, and they can actually be cost effective by having someone else work on that level.
You and your spouse may even agree to meet in a two-way meeting to discuss certain issues if you are both comfortable doing this. It can save time and costs if a safe environment can be established.
What happens between four ways depends so much on what's going on in the four ways and where the clients are. Some clients are very self-contained and don't want a lot of hand-holding and just want a brief conversation, maybe debriefing after the meeting, but they don't want to sit down and hash it out again. They want to be there just for the meeting. Others require much more hand-holding and much more support.
When you meet again, you will continue working toward a resolution of issues. This will include setting short and long-term resolutions regarding assets, debts, parenting issues, and financial support. And though emotions can sometimes threaten to interfere with the process, your lawyer's role will be to keep you focused, enabling you to make good, rational decisions for yourselves and your family.
The interesting thing about impasses is when people are stuck, I like to say, let's get together, the four of us, and talk about how to break this up, how to break the impasse. And if the parties are willing to participate in a brainstorming or some sort of discussion of how to break it, it's no longer an impasse. It's not an impasse yet. So it's taken what was an impasse, or what we thought was an impasse, and moving it more into a working situation.
What makes collaborative practice different is that we essentially do eliminate the court option because people do get stuck and they do reach an impasse. And if you have court as what looks like an easy option, it's very tempting for people to say, well, I'll just file a motion, I'll just go to court. If that's not an option, then they know they have to sit down at a table and work with each other, and they find that there are a lot of other solutions that they hadn't considered. And removing court as an option helps them and encourages them to look at all those other possible options.
When you and your spouse have reached agreement on all the marital issues facing you, you will conclude with a final four-way meeting. This is when you will review and sign the stipulation. This is your detailed written agreement that will be filed with the court. This agreement is a blueprint that you and your spouse have made for the future. And for many, this final meeting not only serves as a legal finality, but an emotionally significant event of closure.
The final meeting can be very celebratory. My favorite story about that is a couple that wrote their own ceremony. They had their witnesses. They had someone come as almost like the minister, and they had the parts for the lawyers. And it was